So hello, good morning, everyone. Good morning, friends in Chile, Mexico, and Hong Kong. I am Susana Munoz, President of the Mexican Chamber of Commerce here in Hong Kong. Thank you for joining us today in this event organized between the Chile Chamber of Commerce, the Mexican Chamber of Commerce in Hong Kong, and the eBRAM Online Dispute Resolution Center of Hong Kong. Before we begin this webinar, I would like to share some notes on why we are organizing this event and why we consider it a relevant topic for Mexico and Chile companies doing business in the Asia-Pacific region. The extensive use of technology in business transactions and expansion of e-commerce has sparked demands for legal services that are unrestricted by geographical and language boundaries. One of Hong Kong's Department of Justice key policy objectives is to position this city as a leading center for international legal and dispute resolution services in the Asia-Pacific region, taking advantages of the opportunities brought by the GBA and the Belt and Road initiatives. Following this, the Inclusive Dispute Avoidance and Resolution Office was established in January 2019 under the Secretary of Justice direct steer to step up the efforts in enhancing the reputation of the city in the international legal dispute resolution and business arenas. One of these efforts is the development of an online platform, the Electronic Business-Related Arbitration and Mediation Platform, or eBRAM, which provides an efficient, cost-effective, and secure platform for online deal-making and resolving disputes among parties in any part of the world. The development of eBRAM platform in Hong Kong will not only facilitate deal-making and dispute resolution for global businesses, investment and trade, but will also provide a valuable opportunity for Hong Kong to showcase its excellent legal foundation, renowned legal and dispute resolution professionals, as well as LawTech development capacity in the Asia-Pacific region. eBRAM also promotes the development of LawTech, including not only the creation of this platform, but also different LawTech services such as Hong Kong Legal Cloud, e-signature services, video conferencing system, and artificial intelligence translation machine. So without further ado, I would like to invite our guest to begin with today's presentation. First, we have Mr. Evaristo Trevino, who is a founder of Mexican Chamber of Commerce, who is also an active member of the Chile Chamber of Commerce here in Hong Kong, and who is an expert in arbitration, who will share some of his experience in commercial dispute resolution for Latin American companies here in Hong Kong. Evaristo is also an associate member of the Charter Institute of Arbitrators. Please, Evaristo, thank you.
Good morning, everyone in Hong Kong, and good evening in Mexico, and good evening in Chile. I would like to ask my friends from the eBRAM to help me with the presentation. While we do that, I want to first of all thank Ms. Munoz from the President of the Mexican Chamber of Commerce, Mr. Gonzalez, President of the Chilean Chamber of Commerce, and our colleagues from eBRAM for inviting me to share with you what I believe to be, well, my thoughts and my experience in international trade between Latin America and China. I'm a Mexican lawyer, and I have been in Hong Kong for 16 years doing international trade law. And I will share with you some of the things I have observed during this time. So today I will share these general thoughts with you. So if I may, Elaine, go with the first slide. I want to start by sharing two graphs. Next one, please, Elaine. Two graphs which are very representative on how trade is going between these regions. So this graph by The Economist shows those countries which are colored in blue are those countries whose main trade partner is the US, or was the US, And those countries colored in red are those whose main trade or commercial partner is China. The map on the top is 2020, and the map in the bottom, 2000, and the map in the bottom is 2020. So as you can see, trade in the world has shifted and changed a lot. And as you can see, and apologies for cutting our friends from Chile and Argentina in the map, but as you can see, Latin America's main trade partner is China, clearly. Next one, please. Additionally, just to have a very brief sight of how trade looks, this is the representation of how much share China has in Latin American exports. For example, Latin America, 34% of all Latin American extraction is exported to China. Extraction are those mining commodities, etc. 20% of all Latin America's agriculture are exported to China. These are figures from last year already reported. And in general, 14% of all exports from Latin America go to China. So you can see how trade is really, really big between these two regions. Next, please. And next. So with trade comes difference, misunderstandings, and sometimes disputes. The most common ones in commercial disputes, from my experience between these two regions, are failure to deliver or delivering products late, some breach of contract in way of not paying, either totally or partially, discrepancies in what we think of quantity or quality, um, price change, and this is very different, IP matters, that this has increased, disputes in IP matters have increased tremendously in the past years. Some changes also in logistics, certifications. For example, a country is importing certain goods from China, and that country has particular regulations in terms of um, toys, plastic, woods, etc., etc., and others. These are the main common or the most common disputes in commercial or in trade. Next, please. Now, I want to talk a little bit about the game rules or the trade rules, because we sometimes tend to think that we are dealing with between Chile and China or Mexico and China with a completely different set of rules in trade. And I will show we're not that different, and that there's a lot of common regulations and common rules to play the trade game and in the same way. Next, please. So in terms of commercial in terms of commercial rules, we have some international documents, international regulation, which applies in Chile, Mexico, China, Hong Kong, and international. In terms of commerce and trade, there's the CISG, which is the United Nations Convention on Contracts for the International Sales of Goods. So this regulation, this international convention, which we are all part of, establishes all the rules for purchases, sales, payment, price, deliveries, etc., etc. Another key piece of international legislation that also China, all these countries that I mentioned are part of, is the UNCITRAL Model Law on International Commercial Arbitration. This means that if countries from these contracting states, Chile, Mexico, China, Hong Kong, etc., enter into arbitration, most of our national arbitration laws will be based on the model law. So we also have the same set of rules for arbitration in our countries. We also have the UNITRAD principles for the unification of private law, which also regulates the formation of the contract, the offer, the acceptance, and more technical things. And finally, and very important, we are all members of the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. This means that if, for example, eBRAM issues an arbitral award in Hong Kong that needs to be enforced in Chile or in Mexico, because Mexico and Chile are part of this convention, it will be easy to enforce it through a particular proceedings in judicial proceedings in this contract. The same goes to China. China is part of the New York Convention. So that means that if an award is issued in Hong Kong, it can be easily recognized and enforced in China. And this in particular in China has improved a lot in the past years. So this is just a few examples of the rules that we are all part of. Next. A little very brief to show you just that in Chinese law, in Mexican law, in Chilean law, in Argentina law, and international law, the main concepts are the same, in particular, information of contracts. So we all consider the same theory of the formation of the contract. So it is not that different. So next, please. So we are all already seeing that we basically know the same rules for international trade. Now, as I was mentioning, with trade comes some different misunderstandings and even disputes. Luckily, there are ways to settle those disputes. I personally, I am a friend of negotiations or mediation, but if this doesn't work or go through, we have the arbitration mechanism. Next, please. Most of the arbitration cases between Chinese companies and Latin American companies that go to arbitration settled in some of these arbitration centers. CTAC, which is in China and has different offices or different branches, Beijing, Shanghai, Shenzhen. The HKIEC, which is the Hong Kong International Arbitration Center. The ICC, which is the International Chamber of Commerce. eBRAM, which is as our colleagues will share in a bit, it's a very interesting alternative to deal with a dispute, either mediation or arbitration. Parties also tend to go to the Singapore International Arbitration Center, and some have been using the Beijing International Arbitration Center. Some others, and I didn't put it here, but some others are settling disputes in the London International Arbitration Center, but this would be the main. I would say that all these institutions have solid grounds for dispute resolution mechanism and rules that are clear to all parties. Next, please. So arbitration in Hong Kong, and I have been living in Hong Kong for 16 years and looking at this. And if you go next, Elaine, please. Right. Doing arbitration in Hong Kong is one of the key things to have a dispute solved rapidly, efficiently, and obviously fairly. In first place, one of the main characteristics is that it is a friendly jurisdiction for arbitration. This means that courts would be referring parties to arbitration and it is highly unlikely that courts in Hong Kong would be entertaining injunctions or other strategies from parties to avoid going to arbitration. So Hong Kong is a very friendly jurisdiction. Hong Kong also has one of the most modern arbitration legislations in the world, together with Singapore, and it is very clear and it's very modern and it's very efficient. We also have top centers that administer arbitration processes, and like eBRAM and the HKIAC. And I wish to also have a mention on that something that may be very different between China, Latin America, and Hong Kong. Hong Kong, as you know, it's a common law jurisdiction. And as a common law jurisdiction, lawyers have two hats, or they can choose to be solicitors, and they can choose to be barristers. Normally, litigation in Hong Kong and even arbitration, barristers or counsels form a big part of it. This is unusual in China, and it is unusual in Chile or in Mexico. In Mexico, in Chile, in Hong Kong, in China and Argentina, we just have lawyers. We just don't have the distinction between barristers and lawyers. In my opinion, this differentiation in arbitration in Hong Kong is being more expensive for the parties, especially when parties are not used to arbitrations, not used to barristers or the distinction between barristers and solicitors. And I wish to share a little bit of some statistics of how long does a process, and this is only with the HKIAC, how long and more or less how much is the cost of doing an arbitration in the Hong Kong International Arbitration Center. So the regular process of an arbitration is 13 months, and the regular cost is 64,000 US in the regular process. There is an expedited process that parties may wish to apply and agree, and usually the duration is 9 months or less, and the costs are lower, around $25,000. And in terms of the tribunal cost, because as you will remember, if you go to arbitration, you need to pay your arbitrators, either one or three. You are basically paying the impartial people who will be determining the outcome of the dispute. So in disputes that are lower than 1 million US, the costs of a tribunal are usually 41,000 in average, 41,000 US. This is on the hourly rate model. And there is also another model called the ad valorem model, which the cost is around $23,000 or $24,000. This on top of the arbitration administration fees that depend, there's a percentage depending on the value of the dispute. Next, please. So as I said, I have very little time to share with you today. So I just want to share with you in very general terms a few conclusions. One, as you see, trade between China and Latin America has increased and continues to increase rapidly. And with trade, disputes may arise. But the rules of the game are not that different between our countries. And we have alternatives to be solving these disputes. Hong Kong is an ideal jurisdiction to solve disputes in the way of mediation and arbitration. And I believe my time is up, and I will pass the floor to my colleagues from eBRAM. Thank you very much.
Thank you. Okay. Thank you very much, Evaristo, for your presentation. We will move on now to the presentation of eBRAM. We have today we have Ms. Rachel So, who is the Chief Marketing Officer of Director of Communications and Marketing of eBRAM in Hong Kong. Before working for eBRAM, she was the Director of Communications and External Affairs at the Law Society of Hong Kong. She has also played a major role in the organization of the first legal-oriented Belt and Road Conference in Hong Kong, and she assisted in the drafting of Hong Kong's manifesto, which was signed by 39 lawyers associations in 29 jurisdictions. And then we will also hear the presentation of Mr. Albert Leung, who is the Chief Technology Officer of eBRAM. He has more than 25 years of experience in telecommunications, media, transportation, and public projects. Mr. Leung is one of the founding members of Offshore Development Center, ODC, at PCCW Solutions. He has also been the Vice Chairman of Hong Kong Chamber of Commerce in China, in Guangdong, and Vice Chairman of Guangzhou Foshan Zhaoqing Chapter of the Federation of Hong Kong Industries. Thank you very much.
Thank you, Susanna, for introducing eBRAM. Ladies and gentlemen, good morning in Hong Kong and good evening in Mexico and Chile. Thank you to the Mexico Chamber and Chile Chamber for inviting eBRAM to participate in this webinar today. Before deep diving into the topic, I would like to go through some intrinsic facts and how online dispute resolution is relevant to the APEC member states like Mexico and Chile. APEC accounts for 60% of the global economic output and 47% of world trade. Within the APEC region, 97% of the companies are MSMEs. COVID-19 pandemic served as an unprecedented wake-up call and a catalyst for change in how things are done. The impact of COVID-19 has not ended in their revenue decline, but also caused challenges to businesses, especially SMEs and MSME. The overarching challenges are namely execution challenges, disruption in the supply chain logistics, and lack of effective dispute resolution mechanisms, leading to over 35% of cross-border.
Hello, sorry, Elaine? Hello, Elaine? We cannot hear you right now.
Sorry, we're having some technical issues. We'll try to solve it right now. We are having some technical issues. We will try to solve them right now. Thank you for your patience.
Hello, everyone. Do you hear me?
Yes, we can hear you now.
Okay, right. There's some technical problem happening here due to some network connections. I'm sorry. May I start again?
Susanna, would you like us to start again from the beginning?
Yes, please. I think it would be a good idea because we missed 3 slides.
3 slides.
I'm sorry for the technical issues, but thank you once again, Susanna, for introducing eBRAM. Ladies and gentlemen, good morning in Hong Kong and good evening in Mexico and Chile. Thank you to the Mexico Chamber and Chile Chamber for inviting eBRAM to participate in this webinar today. Before deep diving into the topic, I would like to go through some intriguing facts and how online dispute resolution is relevant to the APEC member states like Mexico and Chile. APEC accounts for 60% of the global economic output and 47% of world trade. Within the APEC region, 97% of companies are MSMEs. COVID-19 pandemic served as an unprecedented wake-up call and a catalyst for change in how things are done. The impact of COVID it has not ended in revenue decline, but also caused challenges to businesses, especially SMEs and MSMEs. The overarching challenges are namely execution challenges, disruption in the supply chain logistics, and lack of effective dispute resolution mechanisms, leading to over 35% of cross-border disputes remaining unresolved, with an average value of the disputes being $50,000 US. Feedback to a questionnaire from APEC Economic Committee showed that 74% of MSME would like to have the option of using online dispute resolution to resolve their cross-border commercial disputes, whereas 62% of MSME thought ODR offered the growth of the digital economy. So what is online dispute resolution, or ODR? According to Untitled Technical Note on ODR, it is a mechanism for resolving disputes through the use of electronic communications and other information and communication technology, meaning all aspects of the proceeding are conducted online to a platform. It saves a lot of time and traveling expenses. It has been mostly used in IP-related and e-commerce disputes in the past. But after the inception of the COVID-19, we see more demands for ODR for resolving cross-border disputes. eBRAM is devoted to provide one-stop, speedy, and cost-effective online dispute resolution services and LawTech services by harnessing the power of technology to facilitate MSMEs, SMEs, and enterprises in cross-border deal-making, dispute avoidance, and dispute resolution. eBRAM stands for Electronic Business-Related Arbitration and Mediation. We are one of the 6 qualifying arbitral and dispute resolution institutions which are eligible for applying to the PRC court for interim measures. Back in 2018, a group of passionate legal professionals and IT experts found eBRAM in response to the Smart City initiative of Hong Kong Special Administrative Government and the rise of cross-border transactions as a result of the globalization 2.0. As a not-for-profit organization, the eBRAM board is governing body of the company, made up largely of prominent legal and arbitration practitioners and experts from the IT and accounting fields. There are 2 functional committee and 5 standing committee and advisory committee operating under the auspices of the board. The management team is responsible for the daily operation. We are currently operating the eBRAM Apac Odl Platform COVID-19 scheme commissioned by the Hong Kong Special Administrative Government and the eBRAM Online Arbitration Platform. Our online mediation platform is expected to be launched pretty soon. In terms of LawTech services, we offer highly secured video conferencing services, e-signature service, AI machine translation, and Hong Kong Legal Cloud Portal. Albert will go to the LawTech services in his presentation. ODR platform provides in the market can only offer partial ODR services to disputing parties, but eBRAM's platform offers a full-fledged ODR services to party by deploying advanced digital technology, including blockchain, cloud, artificial intelligence AI for translation, and eKYC for identity authentication, which is rarely seen in the world. All the procedures from the submission of a claim to conduct hearings to the rendering of an award are conducted online with a secure, safe, and trusted environment. Let's have a look at our APEC ODR platform. eBRAM's platform was listed as the first and only ODR provider from Hong Kong under the APEC Collaborative Framework for ODR. All businesses in APEC and worldwide facing any kind of cross-border disputes and agreed to refer the dispute to ODR under the eBRAM APEC rules can use the platform to resolve disputes regardless of the claim amount. We adopt a three-stage proceeding: negotiation, mediations, and arbitration, which is flexible and most user-friendly. Our eBRAM APEC rules are based on the Arbitral rules. Award issued by eBRAM is enforceable in 169 jurisdictions under the New York Convention. We encourage you to include our model APEC ODR clause in business contracts so that you can seek recourse from our APEC ODR platform for future disputes. Moving to the features of our APEC platform, you can see that we have a lot of features and functions parties can use, such as AI machine translation, e-signature service, secure communication and document management tools, and blockchain technology. It is a technology-based platform with human element. eBRAM's case management team will administer the cases and we have neutral to assist party to meet an amicable agreement. As mentioned earlier, eBRAM is one of the recognized institutions under the Hong Kong PLC Interim Measure Agreement. Parties to arbitral proceeding administered by eBRAM will be able to apply to the PRC court for interim relief to preserve assets, evidence, and conduct under the PLC law. As Evaristo just mentioned, Hong Kong is the only common law jurisdiction in China. Before passing to Albert, I'd like to quickly recap the advantage of resolving dispute with eBRAM's ODR platform. Firstly, we offer a flexible dispute resolution proceeding, which will be assisted by well-versed neutrals from 35 countries and regions, vetted by eBRAM's appointment committee. Secondly, our platform provides an expedite and cost-effective option for businesses. The administrative fee is ranging from around $127 to $1,000 for a dispute amount from $1,500 to up to $75,000. Thirdly, the proceeding will be held in a highly secured environment, which ensure data security and cyber security. Albert will elaborate in his presentation. Most importantly, the arbitral awards issued by eBRAM are enforceable in 196 jurisdictions under the New York Convention, such as Hong Kong, China, Mexico, and Chile. We'll turn to LawTech services, and I will hand over to Albert, who will present the LawTech services to you.
Thank you, Rachel. Hi, this is Albert. For using the online dispute resolution platform, during the mediation, we would settle the agreement, or during the arbitration, there will be arbitral award. How we could sign related document? Our eBRAM platform provided some LawTech services. First of all is e-signature service. This is breaking geographical barrier using advanced security technologies. Companies can sign legally binding contracts online in a simple and convenient way and instantly receive copies of signed documents, shortening transaction time and facilitate trade. Signing of the awards, agreements, contract can be anywhere and anytime, and the system is equipped with two-factor authentication. It means anyone sign the document will be clarified by one-time password with the user's mobile, and we also have eKYC, electronic know your customer system, to identify the personal identity. All the signed document will be stored and encrypted in eBRAM's blockchain systems. The eKYC verification process, it will verify the user's identification from different regions, including the user's passports, identity card, driving license, or even taxpayer identification number, etc. There are some Asia Pacific region predefined the identity card on our eKYC system, including Hong Kong ID card, Philippines ID, and their passport. In the mainland China, all the local citizens' identification card already preset on our system. Also, Macau, Philippines, Malaysia, Thailand, and Vietnam, their citizen ID card also identified. All other APEC countries' citizens, they can use their passport as eKYC identification means. Next. Our e-signature system combined with e-signing and eKYC document trusted by our former Department of Justice, Teresa Chen. DOJ used eBRAM system to sign some international agreements, including agreements with Arbitral, APEC, Chinese Institute of Hong Kong, etc. Next. Rather than e-signing eKYC, eBRAM also developed our video conferencing system. It will highly similar to commercial product like Zoom or Teams. However, our VC system also provided real-time transcription services and AI translation functionality. Also, notes can be shared and edited. One of the most important differentiation is our VC system is stored and hosted in Hong Kong data center. It complies with Hong Kong privacy law, also assessed by external auditor. All the privacy law complied with GDPR and also Chinese personal information protection law. Next. We also provide AI translation system to support our LawTech system. including ODR, e-signing, VC, deal-making platform, etc. The advantage of using our AI machine translation services is it is specifically developed with legal document translation engine equipped by AI technology. All the machine learning engine trained by AI translation document. This service aims to help enterprise and legal professionals translate their legal documents and enhance their work efficiency. Our AI translation is currently available in English, Chinese, Russian, Arabic, and Spanish. And we also provide an option of human professional translator to edit and refine the machine translated documents. More languages will be rolled out in a later stage. Next, please. Rather than some LawTech functionality, eBRAM will launch a deal-making platform in the Q4. Unlike other online deal source platforms, our deal-making portal is tailor-made to address the challenges of launching a cross-border transaction and at the same time promote dispute avoidance. We offer a one-stop deal-making platform equipped with blockchain, AI, and cloud technologies. Phase 1's functionality includes e-due diligence, yellow page, deal flow management, contract template, virtual meeting with real-time transcription, etc. Finally, cybersecurity is our top priority. eBRAM developed our own system leveraging latest technologies, including artificial intelligence, blockchain, cloud, and soft robotics. As I mentioned before, all our system protected under personal data ordinance in Hong Kong and also comply with GDPR in Europe and PIPL in mainland China. All the data used in our LawTech system are fully encrypted during the transmission. And all of our system before launch will be assessed by external Big 5 auditor to certify that our system comply with privacy laws and also pass all of the application penetration tests. Our system certified by ISO 27001, the highly recognized international cybersecurity standards. All of our system protected by multi-factor authentication. We adopt zero trust strategy. It means all of the user using our platform has to input their username, password, and also one-time password with their mobile. All our system also protected by highest security level of security system, including DDoS protection, firewalls, intrusion detection, web traffic filtering, vulnerability scanning, 7/24 monitoring of network traffic, etc. All of our event system protected by a stringent policy as well. This is end of my part. Thank you very much.
Your trusted partner. This is our aspiration and our pledge to you. eBRAM is here to listen to our user, stakeholder, and provide services beyond your expectation. If you wish to know more about our Apac ODR platform, please visit our designated webpage or scan the QR code. Before wrapping up, I would like to show you a short video of our Apac ODR platform.
With the eBRAM Apac ODR platform, you may resolve your cross-border commercial dispute with any claim amount securely, anywhere, at any time. To start with the platform, you are required to create an account by registering with your email. Enter your email, then click Send Verification Code. A verification code will be sent to your email. Enter the verification code and press Verify Code. Then enter your password and confirm the password to create the account. Once the sign-up is successful, you can log into your account on the sign-in page. To protect your privacy, a verification code will be used every time you log in. Check your registered email for the verification code. Enter your password again to log into the platform. Once you are logged in, agree to the terms and conditions and the personal information collection statement.
If you feel interested in eBRAMs, scan the QR code to access our website or add our LinkedIn account, eBRAM International Online Dispute Resolution Center Limited, and stay tuned to our updates. Thank you.
Thank you very much, Elaine. Thank you very much, Albert, Evaristo. I would like to invite Carlos, but before we move on, first, if we can make a photo of the webinar, because we don't have a photo yet. I think we can share the screen. If we change the screen, that will be great, so we can take a photo of the webinar. Can you help us, Elaine, please? That's great. That's great. So we just make a photo. And I would like to invite now Mr. Carlos Gonzalez, who is president of the Chile-Hong Kong Chamber of Commerce, who is also co-organizer of this event. He will be in charge of the Q&A session and the closing remarks. Thank you very much, Carlos.
Thanks, Susana. And thank you very much, Albert, Rachel, and Evaristo for your presentation. It's a very important topic, as when we were discussing about how we're going to organize this event. We mentioned that this type of situation that nobody wants to get involved, but when you're get involved, you really need the support of trusted partners. I would like to open the room, this system for questions. So if you have any question, please, you can type it in the chat box, or you can also turn on your mic and ask the question directly. I have one starting question, first for Evaristo. Evaristo, have you noticed or seen in any trend in upwards or downwards in the number of cases of overseas dispute resolution situations between Latin American companies and Hong Kong and Chinese companies?
Yes, Carlos, thank you very much for your question, and also thank you for our colleagues in eBRAM for the enlightening presentation, which is very interesting, and I myself are one of those who scanned the QR code. Yes, Carlos, as I was sharing in my presentation, trade has increased a lot in the past 20 years between China and Latin America. 16 years ago, when I arrived to Hong Kong, I saw a lack of contracts, lack of legal documents, lack of, even if there were some sort of written agreements or arrangements, there was also a lack of jurisdiction clause. There was a lack of dispute resolution clause, etc. So these disputes, if any, where the recommendation was not to pursue, because just by entering in the litigation of which law would be applying to a contract, or where would that dispute be settled, either in China or in Mexico, and which law would be applying to the contract, and which law would be applying to the arbitration agreement, if any, etc., was already more money in legal fees than the value of the dispute itself. However, as things have progressed in both regions, more and more we see properly written and signed agreements with a jurisdiction clause and with an arbitration clause. So this has made room for actually increasing the disputes. Now, something interesting also mentioned by eBRAM is that most of the SMEs disputes, the value of that, the value of the dispute, it's quite low, and usually just the legal fees would be way higher. And there is a way around it, which is mediation, which is increasingly coming into topic within this type of trade. So I mean, in concrete, the answer is yes. The number of disputes have arisen. Second, most of the disputes do not end in a arbitral award. Most of the disputes, or I'd say 50-50, at least from the HKIAC numbers, it's around 55-45 that end in an arbitral award. Most of them end in a negotiation. Why? Because parties then see that continuing an arbitration process is very expensive. And finally, yes, more and more cases are being settled either by negotiation or mediation. So I could not say a number. Would be very difficult to tell you a percentage of how many disputes have increased between China and Latin America. But yes, definitely way more, but definitely way more also because now there are more proper agreements in place. And as eBRAM, there's proper centers for dispute resolution mechanisms and so on.
Thank you, Evaristo. I also have one question for or either Rachel or Albert. You have presented some of the very innovative tools that eBRAM has developed. What do you think this LawTech how this LawTech will impact the confidence of the different parties resolving these disputes?
Thank you, Carlos. This is Albert. Let me answer the question. The use of technology to carry out different legal procedures is a global trend. The continuous development of LawTech, especially during the pandemic, brings more convenience and saves times and costs for the business sector. LawTech enables the public to access to the justice easier. It provides cost-effective and time-saving alternatives to people to have more accessible means to exercise their legal rights and resolve their issues fairly. LawTech also reduces the chance of human errors and makes legal procedures safer and more efficient. Take eBRAM as an example. We have developed our platform leveraging latest technologies, including AI, blockchain, cloud, soft robotics. Cyber security and data privacy are our top priority to ensure the protection of information in the eBRAM platform and communication. We're confident that with our developed platform with stringent requirements on cyber security and data privacy, all comply with Hong Kong, mainland China law and GDPR with the most stringent data privacy law in Europe. Our LawTech system would bring confidence to the parties using the ODR resolving cross-border dispute. Thank you. I hope I can answer your questions, Carl. Thank you very much.
Yes, thank you very much, Albert. Actually, it does. And during the presentation, you mentioned that there has been a big impact on SMEs and MSMEs companies. Do you think that this LawTech and the ODR will boost the business sector, particularly for this type of companies?
Thank you, Carlos. Let me answer this question. In fact, LawTech is the future way of doing business. As mentioned by Albert, we are developing our deal-making platform, provide a portal which people can meet and do business. If you have a deal or you have some products, merchandise to sell, you can be listed on our yellow page that people can search, and then they can come to you to have some businesses do. For the ODR, it could provide a safety net to businesses. If you have a low-cost mechanism to resolve disputes, it will provide more flexibility to businesses. During the COVID-19 pandemic, negotiation and hearing were done by using virtual conferencing system. People are getting more comfortable with the digitalization of legal proceeding. Other LawTech applications such as e-signature, cloud storage would enhance the work efficiency enormously. The development of LawTech also allow enterprises and organizations to expand their business scope in many different ways, from just like avoidance of disputes to deal making. Moreover, cross-border industry exchange would be also promoted as more people embrace the advantage of the LawTech, such as time and cost saving, breaking the language barrier that by using our virtual conferencing system, which equipped it with real-time e-transcription, you can talk to different people with your own language, but you understand their language instantly. and provide a private and secured environment for business negotiation and dispute resolutions. Have I answered your questions?
Thank you, Rachel. I have one last minute if anybody else has a question. I might have one more, Rachel or Albert. You mentioned one of the services provided is the e-signing, and
Yes.
that was aiming mainly for making contracts, for signing contracts. But is it also usable for other type of documents like internal documentation?
Yes, of course. Our e-signing services is admissible in Hong Kong, like other e-signing services. It is depends on the law of the local law, whether the government accept e-sign or digital sign document, because some jurisdictions still insist to have wetting, but most of the jurisdictions allow signing document with e-signatures. It could be signed for business contract, but it required both party agree on such kind of like means. Secondly, it could be sign any HR contract with your staff, employees, also some MOU.
Well, thank you very much. We have run out of time. Thank you very much once again to eBRAM, to Evaristo for the presentation. Also thanks to the Mexican Chamber of Commerce and also members from the Chile Hong Kong Chamber of Commerce for participating in this event and also for help us to organize. So have a great day. I don't know, Susanna, if you want to say something more. For me, I'm very happy to see and listen some known faces.
No, thank you very much for all the participants today. Thank you for your time.
Thank you.
Thank you.
Have a good day.
Good day and good night.
And good night.
You are currently the only person in this conference.